Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and this morning I'm looking at a book which has come to us from Informa, part of Routledge and the Taylor and Francis group. This is an interesting book. It's this one here, Laytime and Demurrage. Now in a 7th edition by John Schofield. It's been around a while. We'll have a look at the book in a minute. It's part of the Lloyds Shipping Law Library series. And we've given it a title. It's available in hardback and as an ebook. As I say, 7th edition. Elizabeth and I talked about the book, and we've given it a title from Lloyds Shipping Law Library, a leading shipping law text on Laytime and Demurrage, now in a new 7th edition. Now I'm going to get on to what Laytime and Demurrage are for people who don't know, or people who haven't got very much of an idea. This is an important book, and one of many which Informa produce for us, which are the backbone, in this case of maritime law, the backbone of where the law actually is as far as we the practitioners and the judiciary find it. And that's really why these books are so important. We can't do our work without them, and I say this quite regularly with things like the Informa series and Sweet and Maxwell and some of the big law publishers. These books are absolutely fundamental to what we do in terms of advising people, because this is where the law is set down. This is the front anyway. The side of the book, with the actual spine there's nothing on the back, but you see it's the Lloyds Shipping Law Library. Now if we go in, I'm going to go to the front first of all and show you that's the Lloyds Library, Shipping Law Library listed there. There are quite a lot of books. They all are absolutely fundamental to fundamental statements of law in modern legal practice. There's the front page, and then there's some very nice little dedications there, and I'm sure the author knows who they are. I think I can guess, but I do put that in. The contents are there, and then you can see the chapters going all the way through, detailed contents all the way through. Then you've got, when we get past the contents themselves, there's a preface to the new 7th edition which John has written. Then you've got a table of cases there, and after the table of cases you get just a few statutes just thrown in, and after that we get to the general principles. And it starts off right at the beginning. Laytime and Demurrage comprise one aspect of English maritime law, in particular law relating to voyage charters. So that's where we start. The present law has for the most part been developed by judicial interpretation of clauses in commercial charter parties over the last 150 years. So you can see very much common law based concept. Back of the book, it's under 600 pages. There is the index, very much the style of Informa here, and then you've got 3 main appendices at the back, and you can actually see paragraph numbering, and you can see footnoting, so there's a lot of information. The index itself, if I can just point out, actually refers to paragraph numbering, not to page numbering, so that's, and exactly the same thing applies when you look at the index right at the front. You see it's actually referring to paragraph numbering. So, and if we just open it in the middle, you can see again interruptions and exceptions to laytime. An important book, and anybody involved in shipping law, maritime law, whatever you want to call it, will find this book fundamental. If you don't know about it, obviously, and you're new to this, it's brand new. Most people will know about the book and what they're looking for, depending on what advice they are being asked to provide. Now, what do we say about the book? Well, shortish review, this one, and what I'm saying is that from Lloyds Shipping Law Library comes this new 7th edition of Laytime and Demurrage, recently published by Informa from Routledge. And since 1986, when the first edition was published, this text has become the definitive work in the often abstruse and complicated area of shipping law. I have to say that because it is a bit complex. I did this for my bar finals, and I do understand how confusing it can be to people outside this particular area of substantive law. But this particular book and the whole series are extremely helpful for anybody who is advising clients, as I've indicated earlier. The author, of course, is an expert. John Schofield has written actually the 5th and the 6th editions of the book, and he discusses the often elusive meaning of the term demurrage, which seems to defy precise definition, although it is useful to know that the term comes from the Latin word for delay. And if one notes the author's quote from the judgment in Harris and Jacobs, demurrage can be described, quote, as the agreed amount of damage which is to be paid for the delay of the ship caused by a default of the charters at either the commencement or the end of the voyage, which gives you, if I can say, a little bit of latitude. Now, demurrage then is due as and when the lay time has been exceeded, hence the other term. Lay time, that means the time allowed for the receiving of or the discharging of the ship's cargo, which is set out in Appendix A at the back. Now, perhaps to oversimplify, this means basically that the shipment has been received late, and the demurrage is the penalty payment, which has been authoritatively described as a type of recoverable liquidated damage, or liquidated damages. And the issue of breach of contract then emerges, and of course very much part, of course, of the law of contract itself, but of course with international and other implications. And the new edition, which is now the 7th, reflects the fact that new developments and new cases have emerged since the last edition was published in 2011. And there's a quote here: a number of cases have reached the court, says the author, and have modified, or at least clarified, the law relating to laytime and demurrage. And here the author expresses concern over moves to impose regulatory control when detention or demurrage is payable, adding that this development was opposed by the World Shipping Council on behalf of the industry generally. Whether anything will come of it, he says, we will have to wait and see. And of course that's really one of the points about why we get these new editions coming, because there are changes and we need to know what's going on. In the meantime, of course, this excellent text remains the definitive work in this area of shipping law, and it's, as I said, part of the Lloyds Library anyway, and in particular law relating in this case to voyage charters. No pun intended, this new edition has been made easier to navigate via an improved index which makes specific topics easier to look up, and I did find it quite easy to use it. And as does, of course, the detailed 7 pages tables of cases and contents, rather. The extensive tables of cases themselves, which then follow the contents and the statutes, a small number, are included, together with the extensive footnoting, the numbered paragraphs throughout, and the 3 appendices, which again very much the style of this type of publication. Let me conclude by saying that the book covers virtually every conceivable aspect of this subject. It's undoubtedly an essential purchase, especially with the new edition for all shipping practitioners. The law is stated as at the 15th of November 2015, and I'm recording this in sort of the earlier part of 2016. There's the book again, front and then the spine, and just opening it up in the middle. Commencement of lay time. Again, these are important because you've got definitions which we've given you in the review, which are available in the book when you go through them. But you've got to know when it starts. You've also got interruptions and exceptions. Then you've got other lay time matters. Demurrage then is covered later on. And then detention right at the back. But it's an excellent book. John Schofield is to be commended, and I'd very much like to thank Informa for continuing to produce these books for us. This is where the law is, and I'm very grateful to all of you involved at whatever level to continue supplying what is a really good service for us. Thank you very much indeed. Bye-bye.